Hi, this is Ryan Donovan. I'm CUNA's Chief Advocacy Officer. Thank you for joining me for this week's Advocacy Update audio briefing. Here are three things that you need to know about credit union advocacy this week. First thing is ABA versus NCUA. This was litigation that the American Bankers Association brought against the National Credit Union Administration related to the NCUA's new field of membership rule. The Supreme Court announced this morning that it will not consider this case, effectively handing NCUA the victory that it earned at the appeals court level. From a litigation perspective, what this means is that the court affirmed its Chevron doctrine that gives deference to executive agencies implementing laws passed by Congress. For credit unions, what it means is that NCUA was well within its authority to expand field of membership opportunities for community chartered credit unions. And in fact, it could possibly even go further. We're going to be working with Congress and NCUA to make sure that credit union membership is inclusive, that all that are able to join credit unions can, and that the law reflects that. This litigation and the victory that NCUA credit unions, consumers, and communities won today is an important step in that direction. The second thing you need to know is the Supreme Court also issued a ruling in the SELA Law versus CFPB case. This is a case that was brought against the Bureau that questioned the constitutionality of the Bureau and specifically focused on the for-cause provision in Title X related to whether the president could fire the CFPB director for anything but for cause. And what the court ruled in this case was that the for-cause provision is unconstitutional. So for now, the CFPB can continue to operate as an agency, but its director is subject to removal at will by the president. We were involved in this case with an amicus brief, and the message that we really wanted to get across to the court was that we believe that there should be a commission at the CFPB, and we were trying to set up a scenario in which Congress was forced to go back and implement a commission as President Obama and Elizabeth Warren first proposed way back in 2009, and as Republicans supported in the early years of the CFPB. The elimination of the for-cause provision actually makes the CFPB less of an independent agency, and it could inspire future Congresses to consider whether a commission is appropriate for the Bureau. We're going to continue to push on this question in Congress in the coming years. The third thing to know about advocacy this week is that the National Defense Authorization Act is under consideration in both the Senate and also in the House Armed Services Committee this week. We have concerns with the provision in the Senate version that would allow banks rent-free access to military bases on par with access that credit unions currently have. We expect that the Senate will pass a version of the bill with that provision in it. There's no similar provision in the House bill. And in recent years, this has been sort of the conflict. The Senate has passed legislation with the provision, the House has not, and the provision was ultimately eliminated in a conference committee. We'll be pushing for the same outcome this year. We have strong support for our view in the House of Representatives, and hopefully will prevail in the conference committee later this week. That's what's going on this week. Thanks for joining me for this update. And if you have any questions, don't hesitate to reach out. Thanks so much. Bye.